Good afternoon, everyone. It's 12 o'clock, so let's get started. Today's webinar is chock full of valuable information, and we want to be sure we get to all of it. My name is Patty Lyons-Bousquet. I'm part of the business development team here at KMA Human Resources Consulting, and I want to thank everybody for being here today. Today's webinar, Navigating the ADA's Reasonable Accommodation Requirements with Rachel Flynn and Fran DeLuca. We know your time is valuable and are confident that you'll take a lot of great learnings from today's session. If time allows, we will have a Q&A at the end. If for some reason we don't get to all of your questions, we'll reach out sometime next week, and we'll also be sending your SHRM professional development credits out. So now I would like to introduce you to our speakers today. We have Rachel Flynn and Fran DeLuca. Rachel Flynn is the Human Resources Services Manager for Compliance with KMA. Rachel has enjoyed a varied career in employment compliance areas, serving as legal counsel, human resources director, and employee relations consultant at Fortune 100 companies, nonprofit organizations, and startup businesses. Rachel is a graduate of Indiana University, Bloomington, and Loyola University, Chicago School of Law. Rachel also holds a master's degree in creative writing. Fran is a member of the firm Epstein Becker Green, where he represents management and high-stakes employment litigation. Regardless of the type of claim, Fran develops detailed and creative litigation strategies to obtain favorable results for his clients. In addition to helping clients prevail in the courtroom, Fran actively works with them to stay out of it by reducing the legal and reputational risks associated with significant employment claims. Fran is a graduate of Roger Williams University and Boston University School of Law, and he is admitted to the bar in both Rhode Island and Massachusetts. Now I'd like to take a moment to remind everybody that this presentation is being provided for informational purposes only. It's not intended and should not be construed to constitute legal advice. Please consult with your attorney in connection with any fact-specific situation under either federal, state, and/or local laws that may impose additional obligations on you and your company or organization. Now I'm going to hand it over to Rachel and Fran to take it away.
Thanks so much, Patty. Welcome, everyone. Wonderful to have you. A quick roadmap of the next hour. We're going to go through why ADA compliance is important, overview of the impact of non-compliance, and then on to the accommodation requirement, where we'll give definitions and practical pointers. Next, we'll walk through the interactive process, including documentation steps. And then finally, before we get to your questions, we'll be talking through best practices around the accommodation practice. Hi, Fran, you ready to dive in?
Absolutely. And thank you, Patty, for the intro. Thank you, Rachel, for setting that up. And thank you, everyone, for joining us this afternoon. So as Rachel said, we're going to lead in with why ADA compliance is so important right now. And we're going to go over 3 reasons for why that's the case. The first one, ADA claims are increasingly popular. Last month, the EEOC released its annual report and charge statistics, and it showed that 34% of every EEOC charge filed alleged disability discrimination. That is the highest of any protected class. The annual report, which comments on the EEOC's litigation activity, showed that just under a third, 30% of the EEOC's merits lawsuits, that's when the EEOC takes a charge, investigates, thinks there's something there, and they proceed with a lawsuit in federal court in their own name. 30% involve disability discrimination. That's really a stark figure, because you have to think about how many protected categories the EEOC enforces and protects: race, religion, sex, sexual orientation, age. It goes on and on, national origin, but 30% of the suits they filed are disability, and 41% of the suits they resolved involve disability discrimination. That almost half of their resolved lawsuits, their settlements, involve disability discrimination. And we'll talk about why that is in a couple of slides. And here, the key fact to note, out of those resolved lawsuits, over half, 54%, involved a claim that an employer had failed to accommodate an employee's disability. So here in this chart, you can see the three most popular and common charges filed with the EEOC. And you can see that in 18, disability, race, and sex were all kind of tied. And then in 19, you see disability pull away a little bit. And then in 20, you really see it pull away from sex and race. And that trend has only continued. The gap has widened. If you look at the recent data for 2022, you have 34% of EEOC charges involving disability claims, and then you have about 28 and 27 for race and sex. One comment on this slide, we see this trend, and it's not on the page, but we see this trend going back to about 2010 or so, and that's when the ADA Amendments Act, which took effect in 2008, we really saw a lot more litigation under that. And the Amendments Act watered down the requirement for what it means to have a disability. So that's when we really saw this picking up, but it really took on additional steam in 18.
Yeah, and you know, Fran, speaking of trends, you and I talked a bit about this offline, and I think that many of the HR professionals on this call have noticed the trending sensitivity and impacts of mental health in the workplace overall. Can you talk a little bit about your observations and experience in mental health issues with regard to disability claims and accommodations?
Absolutely. So anecdotally, the majority of the disabilities I see that I help clients deal with are mental health. They're very, very popular. And I did some digging, and the EEOC tracks this data, and it's tracked it since 1997. So you can see here on this chart, in 1997, there were not one claim alleging PTSD filed with the EEOC. And then that ticked up a bit in 2010 to about just around 2%, and it ticks up again in 2022 to 8%. You might think 8%, that's not that high. It doesn't sound like a big number. It doesn't sound like the 34% we were talking about when we were looking at the top charges with the EEOC, but it is a huge number. The EEOC tracks the disabilities that complainants allege, and they fall into about 45 or 48 buckets. So you're talking almost 50 different disabilities. And you have to remember, there is a catch-all bucket for unspecified disability. That's when a complainant files a charge that's bare bones and they don't say what their disability is. That's actually the most common. Unspecified is number one. It's about 25% this year. But number two is anxiety. And you can see that ticking up. 2.5%, 97, 5.3% of disabilities alleged in 10, up to 12 last year. That's number two. Number three is depression. It stayed pretty consistent at 7.5, now 8%. And PTSD is actually, I think, number 4 or 5. So these account for the most common specifically identified disabilities in EEOC charges. So the second reason why ADA compliance is so important, accommodation claims are very easy to prove. As I mentioned before, the definition of disability is expansive, and Congress said it has to be construed broadly in favor of coverage. It's a bit much to say that every impairment, remember, a disability is an impairment that substantially limits a major life activity, or it's a record of having such an impairment. Or there's a third option, it's regarded as having such an impairment. When we're talking about accommodations, only actual impairments and record of impairment cases involve accommodations. An employee who's regarded as having a disability does not get an accommodation. But that concept of impairment is very broad. In practice, most impairments are going to be disabilities. Not all, but a lot will be. Another key fact that distinguishes disability claims from, say, race or sex or national origin You don't need to show intent to discriminate to win a failure to accommodate claim. An employee can establish liability for a failure to accommodate without any showing that the employer harbored some kind of discriminatory animus or bias against disabled employees. Don't need it. The third, an employer's burden to show that an accommodation would be an undue hardship, which is a defense to these claims, is very high. An undue hardship under the ADA is a significant difficulty or expense that would arise from granting the employee an accommodation. It's not any difficulty or expense. It has to be significant. And yeah, go ahead, Rachel. Sorry.
Oh, I'm so sorry. I was noticing in the upcoming bullet, the retaliation claim aspect of disability claims. And, that may be a new concept for several people on this call, where that kind of claim is separate and distinct from the discrimination claim itself, but they're often coupled up. Retaliation claims are often the add-on or the additional claim that shows up, if not all the time, at least the majority of the time.
So this is a recent trend, Rachel. That's right. So we have to remember there are disability discrimination claims, which are you took action against me because of my disability, or you didn't accommodate my disability. So that's discrimination. There's also retaliation. Retaliation, broadly speaking, is an employer takes adverse action against an employee for engaging in protected activity under one of the employment laws. So they filed a charge with EEOC. They complained about harassment to HR. That's protected activity. The EEOC and recently courts even have been saying asking for an accommodation is protected activity. And an employer can't take action against an employee for doing that. And you might think, what does that add? How is that any different from a plain old failure to accommodate claim? It's different in two ways. In retaliation, under retaliation claims, an employee doesn't have to actually be entitled to an accommodation. They just have to reasonably believe that they're entitled to an accommodation, because the standard for retaliation is, did the employee reasonably and in good faith believe that what they were doing, here asking for an accommodation, was protected by an employment law? So it's a lower burden. The other way it's a kind of a watered down claim for employees is the standard for showing adverse action for retaliation is much lower, much lower. For discrimination, they'd have to show a denial of the requested accommodation that resulted in some kind of adverse action. For retaliation, the employee just has to show material adversity, which means something that might dissuade a reasonable employee from engaging in protected activity. Here, asking for an accommodation. So it's watered down in two ways and expands the protections that employees have. And what's the last reason these claims are so popular? They carry significant exposure. And I have 3 very recent jury verdicts on this slide, and I got them from all over the country. And I did that intentionally because we have a recent one in Massachusetts, and you can see very high, $24 million in a failure to accommodate case. But you also have the Western District of Texas. This is a very employer-friendly court. This is where we would want to be if we were litigating one of these claims. And it's still $3.7 million. That's very high in an employment case. And then we have this California case about $6 million. What's key to note here is these involved bigger companies, which means the punitive damages award, the damages that the jury issues with the intent to punish the employer for breaking the law, can be higher. The bigger the company, typically, the bigger the punitive damages award. But a key thing to remember here is large portions of these awards were also emotional distress, which have nothing to do with the size of the company. It has nothing to do with the company's ability to pay the award. And in the Marquez case, the Texas case, the emotional distress award was almost $2 million. They were enormous. So juries punish people, employers, who don't accommodate employees' disabilities. So let's move on to section 2. What is a reasonable accommodation? Well, here we have the components of it. It's really two things. It's an accommodation, which is a modification to the way work is done or the work environment itself. So making doorways accessible. Maybe it's making an exception to a policy. Maybe it's having a high definition monitor for a seeing impaired employee. It can be any number of things. It's changing the way the workplace looks or the way work is done. The other component is it has to be reasonable. Employers are only required to grant reasonable accommodations. What does that mean? It means feasible or plausible, typically, or in the run of cases, in the average case. And it also means the accommodation has to be effective for its purpose. It has to actually enable the employee to work, to do the work the employee is accustomed to doing. And one thing to remember, it's not necessarily what the employee requests. An employer has ultimate discretion to decide between equally effective accommodations. Now, one thing, there's an overarching principle. We're not going to talk about it a lot today. It's going to come up, but to get into the weeds, we would really need a separate hour, at least an hour. And that is, there are defenses to reasonable accommodation claims. There are reasons not to grant them that have nothing to do with the reasonableness or unreasonableness of the accommodation. And those are undue hardship, which we already talked about briefly, significant difficulty or expense, or direct threat. That would be an employee, because of his or her condition, poses a threat to himself or herself that can't be alleviated through a reasonable accommodation. And what's so important to remember, each request has to be evaluated and looked at on an individual basis. It's really hard to have blanket rules that say, not doing this in this department, never doing that. That is completely contradictory to the whole concept of reasonable accommodation and interactive process. So let's talk about some examples. What makes an accommodation, or what is a reasonable accommodation? Well, making existing facilities accessible. We talked about that. Maybe it's installing a ramp, expanding a doorway, job restructuring, changing the way the job is done. We'll talk about that a bit in more detail when we go to the first bullet under unreasonable accommodations. Modifying schedules, looking if somebody has a need for an appointment 3 days a week early in the morning, and we could stagger their start time so they come in a half hour later and maybe stay a half hour later. That could be a reasonable accommodation. Acquiring or modifying equipment. This is like the monitor that is high def, or maybe talk to text software. Changing policies. Employers have a lot of policies that they manage. One could be in-office work could be considered a policy that you might need to change or consider changing. And we'll talk about that later. We got a lot of questions about that before the talk. Providing leave, intermittent leave, or continuous leave can be a reasonable accommodation. And I don't want to go too far off track here, but there is a new as about 4 months ago, guidance letter from the DOL under the FMLA, so not the ADA, but the FMLA on intermittent leave. And it's a really, really important letter to keep in mind. And there is an ADA component, I promise. The letter basically dealt with a situation where an employer received about 40 requests for intermittent leave under the FMLA, all from employees in the same department, all alleging almost the exact same condition, and all coming from the same medical provider. And all the employees said, we have this condition and we can't work mandatory overtime as a result. And the employer said, I'd like to look at this as an ADA request because we have the concept of undue hardship and we can't grant these without significant difficulty and expense. The DOL said, no. Employees have protected rights under the FMLA. An employer can't choose which statute applies. An employee can. And under FMLA, employees get intermittent leave regardless of the impact on the business. Now, they have to do their best to schedule it, not to unduly interfere with operations, But here, it wasn't a question of scheduling, it was a question of granting leave itself. And the DOL said the employer had to do it. And the key there is the DOL also said this could go on in perpetuity. If the employees never exhaust their FMLA banks, they could have intermittent leave, excusing them from mandatory overtime forever. So it's a really, really important decision or opinion for a lot of reasons, and just wanted you to be aware of it. The final accommodation here, reassignment to a vacant position. This is the accommodation of last resort. We want the employee to be in their job or returning to their job, the job they actually held. And if we can't do that, only then do we look to reassignment.
So, Fran, let me pick up on that just a little bit. How would reassignment work necessarily? I mean, I think that most folks know that you don't have to create a new position for an accommodated employee. But if there is a position open in the organization for which the disabled employee, who's requesting an accommodation for which they're qualified, does the employer need to what we call lift and shift, like just move that employee into the spot, or can it be a competitive hiring process? Can they vet other candidates and put the disabled employee in the pool, in the mix? What are your thoughts on that?
So a few years ago, across the country, it was lift and shift. I'd say maybe 5-10 years ago, it was lift and shift was the kind of agreed upon approach by all the federal courts, by the EEOC. But recently, over the past couple of years, especially this last year, there have been some federal courts that have said, in our jurisdiction, it's not lift and shift. If an employer can show that there's a fantastic, over-the-top, unbelievable, once-in-a-lifetime candidate, and not hiring that person, and instead hiring a minimally qualified candidate with a disability through the reassignment process, the employer can show that that would be an undue hardship, then the employer can go with the supremely qualified candidate through a competitive interviewing process. So there is some flexibility there, but you really need to look at what law governs. You need to look at the circuit court. The country is broken up, as I'm sure you know, Rachel, into circuits, and federal courts decide, what controls in that circuit. So for instance, in Massachusetts, Maine, New Hampshire, Rhode Island, it's the First Circuit Court of Appeals. In Vermont, Connecticut, New York, it's the Second Circuit. In New Jersey, Pennsylvania, it's the Third Circuit. So you need to look at what courts in your jurisdiction are saying about that, because that is a major point of disagreement right now. So shifting over to the unreasonable accommodations. So there are some accommodations that the courts and the EEOC and state agencies have almost unanimously found to be unreasonable, and employers don't have to grant them. And you don't have to look at undue hardship. You don't have to look at direct threat. On their face, these are unreasonable because in the ordinary, run-of-the-mill average case, that's one of the standards we look at, employers can't grant these. So number one, eliminating an essential function of the job. An employer never has to do that. I mentioned job restructuring. Job restructuring might involve reassigning or eliminating a marginal function. So what's marginal? The EEOC has an example of an accountant, and the accountant's job is to prepare taxes, of course, and assist clients with tax issues. But also the accountant writes articles that the accounting firm puts on their website or sends out to clients about hot topics in accounting that they want their clients to be aware of. And the accountant can't write those articles because of a disability. For some reason, the accountant requires more time to do her day-to-day accounting work, and she doesn't have time to get to the articles. The articles is a marginal function. It's not the reason the job exists. The job exists to do accounting. So you have to look at every job is different. It's fact specific, and look at the job duties and say which one is essential and which are marginal. If it's essential, we don't have to get rid of it through accommodation. If it's marginal, then we do. Key distinction here under the Pregnant Workers Fairness Act proposed regulations. Under the EEOC's PWFA regulations, which are not final yet, the EEOC has until December 29th to finalize them. But what the EEOC is saying right now under PWFA is that an employer has to temporarily excuse the performance of an essential function as a reasonable accommodation for a pregnant employee. So that's a huge difference from ADA and something to keep in mind. And you should monitor if that regulation goes into effect. Sorry, Rachel.
Oh, I was just going to pop in on the second point, that it's deemed across the board unreasonable for employers to lower production standards in similar measurements of job success. This item, along with remote work, is probably one of the most requested accommodations. And, you know, I'm just wondering here, as a subset of this accommodation request that we see all the time, are folks returning from leave and wanting a temporary alleviation of these kind of standards and measurements as they ramp up to, you know, fully reassuming their job. What do you think about that temporary ramp up as an accommodation?
So the ADA would not require it. The ADA says an employer never has to lower production standards as an accommodation. Now, in practice, a lot of employers probably want to grant it because they want their employee to come back to work, and it's more efficient to have somebody who's trained in this job than it is to rehire and retrain. So if an employer is considering doing this, it's very important to be clear in your communications with the employee. You shouldn't say, and we're decreasing your quota from 10 widgets per hour to 5 temporarily. Shouldn't say that. It should say, we're temporarily excusing the performance of an essential function of your job, namely producing 10 widgets per hour, and reducing it to 5. It should make it very clear that it's a temporary excusal of an essential function, because if it's worded differently, the employee later on or another employee could say, producing 10 widgets really isn't an essential function. It is not a production standard. Look, you let so-and-so make 5 widgets an hour, and you didn't say anything there about this being an essential function. So you just want to be very clear in your communication if you do this. Providing personal use items or amenities. So this personal use item would be glasses or a hearing aid. Employers don't have to provide them unless they're a special type of seeing eyeglass, or it's a special type of hearing aid that is required for the particular job. Personal use amenities, that would be something like a refrigerator. If an employee needs to store a certain type of medication and they want to do it, keep it in a private refrigerator in their office, an employer doesn't have to do that. This is a big one, indefinite leave. This is where the courts are unanimous in the concept. Courts say employers don't have to accommodate an employee by granting them leave indefinitely, which means they're not coming back to work. Where courts disagree is, what makes indefinite leave? What evidence can we look at to determine whether leave is indefinite? Some courts will say, oh, well, it's been extended a few times. It's clear this person's not coming back. Other courts are going to be a little more employee friendly, and they're going to look for something in the medical certification that says unknown when issue will resolve, return to work date, unknown, subject to further evaluation. So you have to know the jurisdiction again, but it's super important to look at what the medical provider is saying about the employee's anticipated return to work date. Another a final area where courts are pretty much in unanimous agreement. Employers don't have to accommodate unpredictable, unreliable attendance. The EEOC itself has said that regular, reliable attendance is an essential function of pretty much every job. So here, if you're intermittent leave, if an employee needs intermittent leave under the ADA, it's not required if they can't tell you when they're going to be in and they're letting you know last minute, and it's happening sporadically. It's happening it's not like it's every Monday, it's random times. You wouldn't have to accommodate that. But remember, if the employee is FMLA eligible, they can get FMLA leave on an intermittent basis, and their protections there are a lot greater because we don't have this concept of unreasonable. We don't have this concept of undue hardship under FMLA. So remember that. It's very important when you're looking at any of these statutes to remember, whether it's FMLA, ADA, state law, like workers' comp, employees get the benefit of whichever statute gives them the greatest protections at that point in time. So keep that in mind in pretty much any disability accommodation scenario. So let's turn to the interactive process. The ADA contemplates this idea of a process that an employee and an employer participate in good faith for the purpose of determining the employee's limitations that arise from the disability and the ways the employer can help the employee do his or her job. So the ways the employer can accommodate the employee. Now, during the interactive process, employers and employees should be looking at four things: the nature of the disability, the limitations it causes, the anticipated duration, and potential accommodations to overcome these disabilities. What triggers the interactive process? This is a really, really interesting question. It can be any number of things, but the three to keep in mind: an employee requests an accommodation, and that can be as simple as saying, I need an accommodation for my XYZ, whatever condition, or it could be a bit more nuanced. It could be anything that indicates the employee has a physical or mental impairment and that they may need a modification to the workplace or the way work is done in order to work effectively. A lot of employers here, they get confused. They think, well, they didn't specifically identify a disability and they didn't specifically identify or say they need an accommodation. So we don't have any obligation. Well, no, if they say enough to indicate that they may have an impairment and they may need something to help them do their job, then we get to the step of determining, well, is that impairment a disability? And that those things you may need that you're alluding to, employee, are those reasonable accommodations? We have to have the interactive process to get to the steps of determining disability and accommodation. Another trigger, and this is a hot button issue: an employee exhausts medical leave, typically FMLA, for their own medical condition, and they remain unable to return to work. Does that trigger the interactive process? The courts are split. We have more progressive courts like the Third Circuit, which again is New Jersey, Pennsylvania, saying yes, because let's be real here. Let's be realistic. They have a medical issue. You know about it. They were on FMLA leave. How did they accommodate that medical issue? They took FMLA leave. What do you think they're going to need at the end of FMLA leave? Maybe, most likely, more leave. It at least warrants a discussion. It's a trigger for a discussion of what might you need. Some other courts, more conservative courts, the Fifth Circuit, which is in Texas and has jurisdiction over Mississippi and Texas and Louisiana, the Fifth Circuit says no. FMLA leave says to the employer, I can't work. I cannot perform my job and I need to be out on leave. ADA pretty much says the opposite. It says, I can work. I just might need a reasonable accommodation. So it's really two different questions. So you should look at where you are. As a practical pointer, what I tell clients is, when somebody's nearing the end of FMLA leave or some other leave for their own medical condition, proactively check in with them. Your return to work date is this. If you're not going to be able to return, or you need an accommodation, please let us know. Proactively check in. It'll help keep you out of trouble. If your jurisdiction hasn't determined if it's a trigger or not, it'll make sure you're not the test case. But it will also help you, the employer, kind of get ahead of the game. You'll be making this determination about whether this employee is coming back on a certain date before the employee, blows the return to work date, and you're scrambling to figure out what to do and how long the department is going to be understaffed. It helps you plan proactively. And it also, speaking of proactive, it's also a really good idea while an employee is on FMLA leave, document with the manager or their supervisor the ways in which their absence is interfering with the department's operations. Are we missing deadlines? Is service at a level that we deem as unacceptable? Is employee morale tanking? Are we seeing resignations because employees feel overworked? Document things that may be jeopardizing the department's ability to function, and that this employee's absence may be contributing to. And the reason you're doing that, you're not doing it to take away their FMLA leave. You can't do that. You're doing it so that if their FMLA leave is going to convert or transition to ADA leave when FMLA expires, you now have contemporaneous evidence of why it would be an undue hardship to grant another 2-week or 2-month or 3-month, whatever it is. You have evidence that it will be an undue hardship to continue the leave. And the final trigger for the interactive process, and this one employers forget about sometimes, you learn of the need for an accommodation and a potential impairment because a third party has reported it, or because you see it. You have objective observation of somebody struggling to do their job because of an impairment. Think about an employee who uses a wheelchair and they're struggling to get up a small staircase. I mean, that's very obvious. Or what might not be as obvious, they're struggling to fit in their desk comfortably. Their wheelchair won't let them pull up to their desk in such a way that they can type on their keyboard and use their mouse comfortably. They're pushed far back. I mean, that's an objective observation. That is a trigger for the interactive process. Now, I like to kind of play a game, if you'll entertain me. It's this idea that magic words are not required. The employee doesn't have to walk into HR's office and say, I have a disability under the Americans with Disabilities Act, and I require a reasonable accommodation. That's not the standard, like we talked about. So I'll read each one of these bullet points, and just, show of hands if you can. Let me know if you think it's a sufficient trigger for the interactive process. So I have cancer and will need to adjust my schedule for treatment. Does that trigger the interactive process? Okay, so I think every hand went up. It's just rapid fire. That's obvious. That is a trigger. All right, so how about this one? With my disc issues, I won't be able to stand all day. Does that trigger the interactive process? Again, pretty much every hand. Now, is a disc issue a disability? Well, we don't know. And we won't know that until we go through the process and determine the nature of the limitations. And is standing all day an essential function? Well, that's something that we should look into, but this is enough. We're not making the determination yet. That we're not saying the employee gets an accommodation. We're saying, do we have an obligation to talk about accommodations with the employee? This crosses the threshold. Now we have my migraines make it so tough for me to get into work by 8:30 a.m. So they're going up a little more slowly, but still going up pretty quickly. This is a trigger for sure. This starts the interactive process. How about this one? I've been sneezing so much since they installed the new carpets. Not as many hands this time. I think this one is kind of on the fence. don't we all kind of sneeze when the new carpets are put in or they paint the walls? I mean, right? Well, I think it's enough because sneezing may be indicative of an allergy. And what might the accommodation be? You know, they installed the new carpets. Maybe I need to be moved somewhere where they didn't put the new carpeting in. Or maybe I need to be moved into a private office where I can open my window to at least get fresh air. Or maybe I need an air filtration system in my office. It could be any number of things. I'd say this is probably enough, but I'd also say if you're in doubt, if you're ever in doubt, and you get something like this across your desk, just say, how can I help you? Those simple words will satisfy the employer's obligation to at least start the interactive process. If the employee says, oh, it's not a big deal, I just need I need a box of tissues on my desk or whatever, then so be it. It's done, you're easy, your liability is mitigated or potentially reduced to nothing. Much easier to do that than to ignore it. Final one. Sally's been sleeping at her desk this week. You might think of this as, oh, well, a coworker is ratting out Sally. You know, I think it's again on the fence. I would go to Sally and say, we've noticed you've been sleeping at your desk. Is there anything we can do to help you? Is something going on? Very simple, very basic, kind of obviates the need for any, or obviates the risk. Question here. Let's say we have a policy against sleeping at your desk. And let's say Sally comes out and says, I've been sleeping because of my whatever condition or my treatment. Do we excuse her violation of company policy before we knew about that? And the answer is no, we don't. Employees with disabilities are held to the same disciplinary standards as other employees. So we shouldn't excuse it, but we should potentially look into helping going forward. So what's the role of medical documentation? This is a really common issue. So an employer can request medical documentation when an accommodation or a disability is not obvious. It should not be reflexive. There are some disabilities and accommodations that you don't really need a doctor to tell you. Remember the employee I mentioned with the wheelchair and she couldn't fit into her desk comfortably? Do you really need a doctor's note to tell you this employee is disabled? No. Do you need a doctor's note to tell you maybe they need a desk that's a little higher or a little wider? No, you don't need it every time. But when you do ask for it, it has to be limited. It cannot be a request for the employee's entire medical file. It has to be targeted to the nature, severity, duration, and extent of the employee's limitations. I get this question a lot. An employee drops the ball and doesn't, I'm not participating. I'm not giving you that documentation. Well, then the employee did not participate in the interactive process and they're not entitled to an accommodation. But remember, you need to give employees a reasonable time to produce this documentation. I get a question a lot. Hey, Fran, we know FMLA says employees have 15 days to return their medical documentation or certification to us. What about ADA? The ADA doesn't have a specific time frame, but I do like using the FMLA's 15-day time frame as kind of a good marker. I like that. It's a reasonable amount of time under one federal statute. It seems reasonable to me. It's over 2 weeks. I like using that as a kind of starting point. Now, if an employee says I can't get that medical documentation in 15 days because of my condition, or maybe my doctor's out of the country or something, we make exceptions, I think, but I like that as a starting point. Not required, but I think it's a good practice. And remember, any documentation you receive has to be maintained in a confidential file, cannot go in the employee's personnel file, has to be separate, and access has to be limited, cannot just be given to managers or other employees.
Well, Fran, speaking of confidentiality, I get a question quite frequently, a little bit in a broader scope, which is when there are coworkers in the workplace that notice a an employee getting an accommodation, reduction in hours, what have you, and they want to know what's up, just out of curiosity, or they kind of want to hop on that bandwagon, and they too would like to avail themselves of this accommodation. What's your recommendation on how to respond to questions and a workplace dynamic that may crop up around an accommodation?
That's a really good question. The EEOC takes the position that telling a coworker an employee is receiving an accommodation under the Americans with Disabilities Act violates confidentiality because it indicates that the employee has a disability. So the EEOC in its guidance has said employers can say, we are acting for legitimate business reasons and in compliance with federal law. Now, I'm not crazy about that. It's kind of cold. It's not realistic. We don't communicate that way. And the employee is just going to be like, that didn't tell me anything. And they're going to start gossiping. They're going to start asking around.
Yep.
You know, so I like the EEOC in a case, the EEOC can has limited there are limited cases where it sits kind of like a court and it makes decisions. And there is a case, those are usually public sector cases, but there's a case where the EEOC approved an employer's kind of standard talking point on this. And I like it a little better. We have a policy of assisting any employee who confronts personal challenges in the workplace. And these challenges, by their very nature, are personal. So it's our policy and practice to respect employee privacy. I like that a lot more. It's a little more detailed. It kind of explains why we're not sharing things. And it might tell the employee, hey, if I ever have an issue, I can rest assured that my employer is not going to tell everyone about it. So I like that one better. The EEOC has basically blessed it, so I would go with that one. A couple things about medical documentation before we leave. Managers are different from coworkers. They can be informed of necessary limitations and accommodations. Obviously, that's part of their management role. In the medical documentation you request, if you haven't updated your forms, if you use forms, take a look at them. You need to have GINA language. GINA is the Genetic Information Non-Discrimination Act. If you just ask a doctor for medical information and you get back something about family history and you didn't put a GINA disclaimer in there, you as the employer can be on the hook for kind of encouraging and soliciting a violation of GINA. We're not supposed to know things about family medical history. Finally, PWFA issue, Pregnant Workers Fairness Act. The EEOC's proposed regs say that if you're looking at an accommodation for a pregnant worker, there are some accommodations, kind of like ADA, kind of like we talked about, but there are some that the EEOC has written down and said, these you should really never be asking medical documentation for. Things like water breaks, bathroom breaks, seating, being able to sit and not stand for extended periods of time. These are just pump breaks, lactation breaks. These are so common, and we know that pregnant workers need them, or workers who have just delivered need them, and we don't need to go to a doctor to verify that. And the EEOC says you can't. And remember, there are state laws that say you can't. Massachusetts has a law that says you can't. Rhode Island has a law that says you can't. A lot of California, I believe, has a law that says you can't for certain kinds of pregnancy accommodations. So keep that in mind. All right, so let's talk about best practices in the last 10 minutes here. And this really falls into three kind of buckets: before the interactive process, during the interactive process, and after the interactive process. So before we receive an accommodation request, what's an ADA best practice? Well, we really need to update our job descriptions to ensure they're ADA compliant. There are two cases, brand new, one's from the late last year, one's from a couple months ago, from very conservative employer-friendly courts, the Fifth Circuit and Eighth Circuit. It's Mobley versus St. Luke's Health System. That's the Eighth Circuit. And it's Montague versus United States Postal Service. Both of these cases said to an employer, the court told an employer, working remotely is not an essential function of the job. And how do we know that? Well, it's not in the job description. And they ding the employer for not updating their job description. And they also said these employees worked remotely during COVID. And look at the performance reviews you gave them. 5 out of 5 exceeds expectations. So they were, if it were an essential function, they're doing it at home. They're doing their job at home to your satisfaction. So keep that in mind. You need to, in your job description, explain regular, consistent attendance. Why is that important? Put it in the job description. Don't just assume it. And you need to provide examples of how skills and requirements are critical. So if you are going to update your job description to say that in-office presence is an essential function, you need to explain why it's an essential function. And there's risk. If you don't have something in there, like these 2 cases show, then a court or the EEOC could say it's not essential. If it were, you would have put it in the job description. Manager training. You should train your managers on ADA compliance. They should know how to recognize requests for accommodations. We went over those magic words. We went over objective observation. Somebody struggling to do their job. They should be trained to recognize that. And guess what? You could have the best ironclad, airtight ADA accommodations policy, and it says if you need something, go to HR or our service center. And do you know where employees are going to go? More often than not, they're going to go to their supervisor first. Those magic words, a couple of them I actually pulled from cases, and an employee had told their supervisor some of those bullet points, and the supervisor didn't do anything. And that's why the case went to litigation. They should also know about confidentiality requirements. They're going to know about limitations and accommodations that employees are getting, and they can't tell coworkers about it. And they should just know about how to manage an employee with disabilities. And what that means is they should be trained, managers should be trained on not excusing, failure to meet a requirement as a result of learning about a disability after the fact. They should also know they should not be micromanaging employees' personal lives and going up to them and saying, I think you have a disability. You're not doing this job like you used to, blah, blah, blah. You could get exposed to a regarded as claim if a manager does that. What they should be trained to do is if they see a shortcoming, they should go up to the employee and during the ordinary course of performance management say, you're not doing this job like you used to. Is there any way we can help you? That way you avoid a regarded as claim. And if the employee ever says the employer should have noticed my disability, you did it. You satisfied your obligation. A couple of policies that are hot button issues, 100% healed policies. EEOC has made these an enforcement initiative. 100% healed policy says after a period of leave, you have to come back to work, full return to duty. That totally disregards the concept of reasonable accommodation. What if somebody can come back with a modification to the way work is done? Another issue the EEOC is targeting right now, no fault attendance. That's when you get attendance points for an absence for any reason, and once you get enough, you're given a warning or terminated or whatever the adverse action is. Those can violate the ADA if employees are getting attendance points for ADA protected intermittent or continuous leaves. Let's jump on to after receiving the accommodation request. This is a checklist that you can look at. You should initiate the interactive process promptly. Don't drag your feet. An employer has an obligation in good faith to start the process, but ignoring an employee request sends the wrong message. It tells employees we don't take these issues seriously. And you know what they're going to do? They're going to go to the EEOC. Don't immediately reject an accommodation request, no matter how reasonable it may appear. The interactive process entails a discussion between employers and employees about how employers can help. I think here's a good idea. A good idea is guardrails or bookends, I call them. There are some companies that say, okay, you employee gave us medical documentation and it says you need this accommodation, granted, because your doctor said so. That is going to jeopardize your operations. you should really consider whether it's going to be an undue hardship for you to grant that request. On the other hand, there are companies that say, okay, you're saying you need this accommodation. Can't do that. That's really inconvenient for us. Sorry, denied. Shouldn't do that either, because that will, your operations might be going fine, because you're not going to inconvenience them at all, but your ADA risk is through the roof. You should really be in an interactive discussion of how can I help, and you should ask the employee how is this going to work in practice. Let them explain it. And what happens sometimes is the employee will say, hey, you're right, this is unworkable. And you can go into, well, what else can we do? Be reasonable in your alternatives. Give accommodations that account for the employee's limitations. Don't offer up ones they can't accept. You may need to offer more than one. The idea of stacking. Sometimes they might need one. Their accommodation's unreasonable, but if we gave them two, it might be. Think about an employee who needs to work from home for because of nausea after a treatment or something like that. Well, let's say we can't accommodate work from home because in office is essential. Well, could we move their office closer to the bathroom? That would be one accommodation. And what if we gave them more frequent restroom breaks? Well, that could be two. We're stacking because the first one was unreasonable. Documentation, you want to document the employee's sign off on any accommodation that you offer and that the employee agrees on. It could be through email, it could be a signed document, but you want something to acknowledge the employee bought into this.
Fran, let me just quickly ask a question that comes across my desk all the time, and that is, what if you receive this accommodation request while the employee and the manager or HR are in the midst of a performance review that is not going well, or in the middle of talking through a PIP or a corrective action? All of a sudden, it comes up from the employee that these deficiencies may be the result of a potential disability.
Mm-hmm. That's a really good question. That happens a lot. You don't excuse the corrective action or the consequences that flow from the inability to meet performance standards or meet conduct standards. You don't excuse those consequences, so they still receive the corrective action or the PIP. But what you want to do is, going forward, let's say it's a PIP, you want to take into account the accommodations they might need to do their job in the PIP. So yes, they're still going to get the PIP, but when it's issued, it's not going to hold them to or turn a blind eye to their disability and their need for some kind of modification to allow them to be successful. And here's the final slide. After granting or denying an accommodation request, you want to document any adverse action the employee suffered. This could show a potential retaliation claim, or be evidence against the potential retaliation claim. You want to investigate any allegations of unfair treatment. You want to maintain confidentiality. And one thing to keep in mind, granting an accommodation, the interactive process doesn't just stop when you grant the accommodation. It's ongoing. Periodically check in with the employee. How are things going? Is it still working for you? Oh, do you need it anymore? Do you need something else? Check in, because it shows good faith, satisfies our duties as employers, and does a lot to improve employee morale.
Wow. Thank you, Rachel and Fran, for that informative session. There's just so much to unpack with this topic. I know in preparation, we were talking about how we could do this for an hour every month and still not cover it all. We got a ton of questions, and because we are out of time, what we will be doing is following up on those questions afterwards. Also, you will be receiving your SHRM PDCs by email as well. And again, thank you all for attending today's session. We hope you got a lot out of it. And I wish you all a wonderful day. Thank you.
Thank you.